Good morning, everyone. Welcome to today's episode of PYA's Healthcare Regulatory Roundup Compliance Webinar Series. Today's topic is One Big Beautiful Bill, Lots of Proposed Rules. PYA is happy to present today's webinar on this important topic. You may submit questions during the webinar by typing a message into the Q&A pane of the control panel. Also, immediately following the end of the webinar, you'll be asked to complete a short survey and submit any additional comments. Any questions posed during the webinar will be responded to via email after the webinar. We've posted a PDF copy of the presentation slides for your reference in the resources pane. Also, you'll receive an email later today with a copy of the slides and a recording of the webinar. You can customize your viewing experience by resizing, moving, or minimizing all of the panes within the webinar.net platform. With that, I would like to introduce our presenters, Martie Ross and Kathy Reep.
Thanks, Jennifer. Good morning, everyone. Thank you for joining us today. We're going to split this webinar, spending the first half discussing the healthcare provisions of the One Big Beautiful Bill Act, or as we refer to it, OBBBA. And then the second half, we're going to talk about the CMS proposed payment rules for calendar year 2026. Kathy and I were a little nervous yesterday because we were waiting not very patiently for the hospital for the hospital outpatient prospective payment system rule to drop, which it did at 4:15 Eastern time. So we will talk about key elements of that new proposed regulation as well. So let's jump in both feet first and talk about OBBBA, starting with the Medicaid and ACA premium tax credit provisions. We group these provisions together because these are the ones most likely to have a direct impact on provider reimbursement. Starting with the work requirements, sort of the centerpiece of the Medicaid reforms within OBBBA. Effective beginning in 2027, states will be required to condition eligibility for Medicaid for individuals who are not disabled and not otherwise accepted from the requirement on working or participating in qualifying activities 80 hours or more per month. States may request an additional 2 years for implementation of both the requirements and the verification procedures, but only if they demonstrate a good faith effort toward implementing the work requirements. HHS is scheduled to issue interim regulations by about this time next year. So about 6 months before the requirement actually goes into effect. No, that's an interim final rule, so really no opportunity to comment to CMS's direction. And also they have appropriated $200 million to assist states with implementation of this project. We do not know when states will see that money. Key to this new work requirement are the obligation on states to conduct regular verification. When an individual applies for Medicaid, they must meet the requirements of the work requirement for at least 1 month prior to the application. States may require up to 3 months of continuous work prior to permitting enrollment in the Medicaid program. Then, going forward, at each regularly scheduled redetermination, the state must verify that the individual has maintained compliance to the requirement for at least 1 month since either their initial eligibility determination or the prior redetermination. States, in fact, again, may require more than just 1 month, and they may also require verification more frequently as well. States may also provide hardship exceptions. They are not required to, but they have the option of providing additional hardship exceptions, which would include a qualifying hospitalization, traveling out of your community for ongoing healthcare services, a declared emergency in your community of residence, or the fact that the area in which you reside has a high unemployment rate. Again, not mandatory, optional. CBO estimates the cost, the reduction in spending associated with the work requirement to be $326 billion over a 10-year period. When we talk about OBBBA and its budget impacts, we always discuss it in a 10-year increment. That's how CBO does its score. Next up, from work requirements, there are a number of other eligibility provisions included in this legislation, beginning with the delay in implementation of the Biden-era eligibility and enrollment final rules, delaying that until 2035. These were a series of rules published by the Biden administration, which were intended to make it easier to enroll in Medicaid and to streamline the eligibility process. CBO tags this at $167 billion in savings by effectively keeping people off Medicaid. Effective December 31st of 26, states will be required to conduct eligibility redeterminations at least every 6 months for the expansion population. Current law requires redetermination on an annual basis. Again, for that expansion population, we will move that to every 6 months. CMS is to issue guidance on such redetermination requirements within 180 days of the passage of the legislation. And CBO tags this one at $62 billion. Also starting in 2027, states will be required to phase in additional screening and verification procedures to prevent improper enrollment. So this is the issue of an individual being covered by Medicaid in one state, relocating to another state, and remaining on the original state's Medicaid program, but also then securing eligibility in the new state. So we now have a series of systems that the states will be reviewing to prevent that from occurring. Here, there is $30 million appropriated to CMS for system implementation, but there are no monies, interestingly, appropriated for the states. Presumably, they would be reimbursed at FMAP 50% for administrative costs, but again, no specific appropriation for that purpose. CBO says this is going to gain or reduce spending by $18 billion over the 10 years. Then effective October 1 of 2026, CMS is limiting eligibility for Medicaid to refugees, asylees, they're eliminating eligibility, for refugees, asylees, and humanitarian parolees. Now, Medicaid eligibility will be limited to lawful permanent residents, as well as Cuban, Haitian entrants and citizens of freely associated states, 3 very small island countries. So the CBO says this scores in at $6 billion reduction in Medicaid spending over time. Also of note here and related, action taken by HHS earlier this month, I think the final version was published in the Federal Register yesterday, is a new interpretation of federal law that limits other federal benefits to individuals who do not meet the definition of legal status. And that would extend prohibitions on participation in a number of federal programs. So we'll be paying attention to see how that's implemented over time as well. So we're always dealing on 2 fronts, what we're seeing in the legislation and what we're seeing administratively from the federal agencies. Moving from eligibility, and obviously eligibility impacts providers because you're going to increase the number of uninsured individuals. CBO tags the provisions regarding Medicaid eligibility as reducing enrollment in the program by about 7 million individuals over 10 years. But now let's focus on provider taxes and state-directed payments because this hits you directly in the pocket, as we're going to have changes in the amount of money available to states to make payments to providers. Now, provider taxes are a tool states have used for several years to generate revenue, state revenue, for purposes of drawing down the federal match. These taxes are targeted to providers. So we tax hospitals, we tax nursing facilities. We are capped at 6% of their net patient revenue is what we can set the tax at. These dollars then, you bring down the federal matching funds, and that creates a pool of dollars then that can be used to fund different elements of a Medicaid program, including enhanced reimbursement to providers. And so this has been a vehicle that we've gone from low Medicaid rates in some cases up to Medicare rates, in some cases up to average commercial rates. It varies by state how they've used those provider tax dollars. Now, in OBBBA, we are going to decrease the threshold, which determines the amount that the state can generate in provider tax dollars. And again, that's currently tied to 6% of net patient revenue. For expansion states, and expansion states only, they will be required to reduce their provider tax to comply with decreasing thresholds. They will also be prohibited from implementing any new taxes or in any way expanding existing taxes. The threshold will stair-step down over a number of years, beginning in 2028, where it will go from 6% to 5.5%, and then it will reduce by half a percentage point until 2032, when it reaches the new base, which will be 3.5% of patient revenue. For non-expansion states, they can keep their current provider taxes that have been approved by CMS, but they cannot impose any new taxes or expand existing taxes. The legislation also closes a loophole in the formula that CMS uses to determine if a provider tax is generally redistributive, which is substantially similar to a proposed rule that CMS promulgated on May 14. There are just a handful of states will have their provider tax impacted by this specific provision. CBO scores the provider tax provision at generating $191 billion reduction in federal spending in Medicaid over the next 10 years. However, little asterisk here, our CBO score actually predates the very, very final version of the Senate bill, and it was a last-minute change in the Senate debate on the legislation that moved the starting date from 2007 to 2008. So we pushed back that first step down in the threshold to 2028. And so that 191 billion may be off a couple of $1 billion, a billion here, a billion there, right? But we'll hopefully see a final CBO score at some point in the near future. We have not yet seen that published. However, the critical comparison here is to the House bill. Right. The bill that the House passed way back a million years ago, on May 22nd, it simply froze provider taxes, didn't stair-step down the amount of those taxes. That was going to generate $89 billion. So we've more than doubled the amount of reductions in Medicaid spending. And again, these are provider taxes. These are dollars directly used by the state for spending on the Medicaid program. And they're not able, if those amount of taxes they collect goes down, that means state spending goes down. Relatively straightforward. Again, note, we do have the delay till 2028. I think it was yesterday, Senator Hawley from Missouri has already introduced legislation to even roll back further these cuts to the Medicaid program. Certainly there's a lot of lobbying activity around this. We'll see what happens. I'm not saying this is a wait and see circumstance. Certainly we need to be preparing for these changes in our Medicaid program, acting as if they're going to be implemented, but certainly want you to be aware of the continuing political environment around these issues. Closely related to provider, Kathy, I'm sorry, did you want to add something?
No, you're fine.
Okay. Closely related to provider taxes or state-directed payments, which is when CMS permits a state to provide specific instructions to their Medicaid MCOs to pay a provider a certain rate. You know, the core of managed care is that we want to allow the plans to negotiate rates with providers. But in these instances, the state steps in and says, no, MCO, you're going to pay this rate, or we're going to give you a bolus of money and you're going to have to spend that money in a specific way, distribute it in a certain way to certain types of providers. And again, that state-directed payment has been a tool used by about 29 states to ensure higher rates for their providers. And again, oftentimes up to the level of average commercial rates. Under OBBBA now, there will be no future state-directed payments exceeding 100% of Medicare rates for expansion states. It's 110% for non-expansion states. And an error on the slide, and I apologize, but it's 110 for non-expansion, 100% for expansion states. The prohibition does not extend to new state-directed payments submitted to CMS by May 1st of 2025, or in the case of an SDP that targets rural hospitals, July 4th. Again, this was a provision sort of added in at the last minute to address concerns folks had about the impact of SDPs. There were a number of states that had SDP requests that were in the mix. And so we effectively grandfathered those that are sitting on someone's desk in Baltimore right now, but not necessarily have been finally acted upon by CMS. Also note that this provision says that if you don't have a Medicare rate for a specific service, then the SDP is capped at the Medicaid rate that is specified in the state plan. Already existing state-directed payments that exceed the applicable rate, the state will be required to reduce the rate by 10% each year, beginning with the rating period on or after January 1st of 2028 until you reach the applicable rate. Again, this applies equally in expansion and non-expansion states, and it likely impacts about 30 states throughout the U.S. Example would be Florida, right, Kathy? Is that you're that's the other side of the coin. That's provider taxes.
Provider taxes.
Yeah. Right, but for states that have the state-directed payments that cap at Medicare, that there's going to be no change. Those that have gone above Medicare with their state-directed payments, where there's potential impact. Note that for state-directed payments, there is no exception for nursing facilities and intermediate care facilities. I am remiss for not having addressed that issue with respect to provider taxes. There is an exception to the requirements on provider taxes for those that target nursing facilities and intermediate care facilities. So those provider taxes provider taxes on those specific types of providers are not impacted by OBBBA, but appreciate on the backside the state-directed payments that favor those nursing facilities or intermediate care facilities will be subject to these limitations on SDPs. And for example, room and board nursing facility, not something covered by Medicare, so it would then be the Medicaid rate in the state plan that applies. Here, CMS puts the score at $149 billion in savings. Again, there's an asterisk there because it's based on the 2027 date. That got changed to 28 in the end of the debate. But again, that's still going to compare significantly above the $72 billion that was tagged on the state-directed payment provision within the bill that passed back on May 22 in the House. There are a host of other Medicaid provisions that do not have as significant an impact in terms of dollars and cents, but will have a significant impact as they impact providers, beginning with the retroactive coverage provision. So right now, if you have a patient that qualifies for Medicaid, there will be a look-back period of 3 months before the application, and Medicaid will cover those services if the individual is eligible. Some states have shortened that period under a state plan amendment, but generally the rule is 3 months. Now going forward, it will be limited to a retroactive period of 1 month for the expansion population and just 2 months for the non-expansion population. There are also, clearly impacting providers who have an individual who's uninsured, they get them qualified for Medicaid. You're going to be limited in how far back you're actually going to receive payment for that individual. In terms of cost sharing requirements, effective in October 1st of 2028, states will now be required to impose a $35 cost sharing on expansion adults that fall within the income range of 100 to 138% of federal poverty level. However, we're going to maintain exceptions for specific services and certain populations. So preventative care services, for example, will not be subject to the cost sharing requirement. There are also certain populations that are exempted out as well, and an income cap of 5% of the family income for out-of-pocket expenses. States are also permitted to go higher on these cost-sharing requirements for non-emergency hospital services. So get just this new level of collecting copay obligations from this specific population
It's going to be very
of Medicaid covered individuals.
Very difficult for hospitals to do. $35, you can't even get a bill out the door, probably for $35.
Right.
And process a payment.
It's either collect up front, or what else would you do? Longer term, but still impactful now on providers, is a requirement that beginning in 2030, if a state has a certain error rate in their payments, that they're either paying services for ineligible individuals or they're paying overpayments on the behalf of eligible individuals. If their error rate is too high, their FMAP gets reduced. And currently, I think there is one state that meets the error rate that is specified here in the legislation. So states now incentivized to be doing reviews to ensure both folks are eligible for Medicaid when the payment's made, but also that it is not an improper payment made on behalf of that individual. The good news, there is some good news here, believe it or not. There is a moratorium on the enforcement of the nursing facility minimum staffing requirements through 2034. Somehow at the end of the day, that made it through the bird bath, Kathy. I'm not exactly sure how, but
because
it did end up in the final legislation.
Just pushing it, yes, as opposed to eliminating it.
By 2034. They eliminated the special FMAP for emergency services furnished to aliens beginning in October of 2026. So there's been a higher FMAP match for these services. Instead, now a state will just receive its usual FMAP for those services provided to illegal aliens. Expanded access to home and community-based services for those. Right now, HCBS services are limited to individuals who would otherwise qualify for institutional care. We're now expanding qualification to include those who do not require institutionalization beginning in July of 2028. However, there are requirements that are associated with this with regard to waiting lists. So a state can only expand out its coverage if its waiting list is sufficiently short. And for many states, there are very, very long HCBS waiting lists currently. So it may be a solution that doesn't really solve a problem. There are also changes to budget neutrality rules, prohibition on payment of Medicaid funds to Planned Parenthood for 1 year in the Senate version. And Kathy, let me hand it over to you for what you're concerned about and what's missing in this bill.
This one, this has been pushed down the road. This is a provision related to Medicaid disproportionate share that came about under the Affordable Care Act with the idea that so many more people would be covered under the Affordable Care Act and between expanded Medicaid and the exchange, that they had built into that a reduction in Medicaid disproportionate share funding of $32 billion. It was to be taken to the tune of $8 billion a year over 4 years, beginning in 2014. It has been pushed and pushed and pushed down the road. Well, the House bill actually called for pushing this down the road again so that they delayed it until beginning of federal fiscal year 2029. What happened with the Senate bill is they didn't address this provision, therefore it was struck. And unless Congress takes action between now and I guess September 1st, we're going to see an $8 billion Medicaid dish hit. And this will be, again, $8 billion a year over 4 years. Martie has already talked about the funding cuts that your states are going to see and providers are going to, therefore, result in reductions in payments. This would be one more hit from a Medicaid disproportionate share perspective. $8 billion a year for 4 years.
In addition to the Medicaid cuts, we also have the cuts to the ACA Marketplace premium tax credits. That involves a series of eligibility changes that when an individual can qualify for the premium tax credits, as well as the eligibility, when they can qualify, as well as the hoops they have to go through to prove eligibility. Those are detailed on the slide. Again, what's most concerning here is what's missing from this legislation, which would be an extension of the enhanced premium tax credits that are set to expire at the end of 2025. The CBO has estimated that the expiration of those tax cuts at the end of this year will result in an increase in the uninsured by 4.2 million by 2034. Add to that also the new ACA Marketplace Integrity and Affordability Final Rule that was published in June of this year. CBO tags that as adding another $900,000, 900,000 individuals, as uninsured. So these are immediate impacts. This isn't we're going to wait around till 2028. These are what's going to happen beginning in January as folks that have been covered under these ACA exchange plans no longer will have coverage. Okay, shifting gears, let's talk briefly about OBBBA's Rural Health Transformation Program. Again, added in the Senate. Oops, I did not hit. There we go. There we go. Added in the Senate kind of at the last minute to win votes. It's a $50 billion fund paid out over 5 years starting next year. It is not dollars that go directly to hospitals, but instead it goes to states for distribution. The states will be required to submit an application by December 31st. That application consists of a rural health transformation plan, and you see there on the screen the details of that plan. The CMS administrator then is required to either approve or deny each state application no later than December 31st. So we suspect that the applications will actually be due before the day on which the administrator will actually decide how the money will be distributed. For those states that have approved applications, they will receive an allotment of two types. The first allotment is the equal allotment. For that $10 billion distributed each year, $5 billion is going to be divided equally among all states with approved applications. So if New Jersey and Rhode Island that have no rural hospitals apply and they're approved, and along with the other 48 states, then everyone's going to get $100 million from the first pool. Then for the second $5 billion, that is allotted by the administrator, CMS, Dr. Oz, to at least 25% of states with approved applications. And you see there again on the screen that the administrator, is to consider in making those allotments. So we could have some significant disparity once you get beyond that initial equally distributed $5 billion, but as few as 13 states could share the other $5 billion. It is unclear at this point from the language in the statute whether the allotments are all made, all determined at the beginning of the 5-year period, or whether there's a reassessment each year. And of course, the most concerning part of all of this is the language that says the administrator's decisions are not subject to administrative or judicial review. So very limited opportunity, if any, to challenge the decisions made by the administrator other than through the political process. States are then required to expend their terms on terms and conditions set by the administrator, and that must include a requirement that the state have a plan to use its allotment to carry out at least 3 of the items you can see specified on the screen. So, and apparently, and again, reading the language, it appears your use of the funds as a state are limited to those that you've identified on the list, and you provided a plan for using those dollars. What's not here is a dollar-for-dollar replacement of the funds that the state rural hospitals lose as a result of the Medicaid cuts. The reason we have this fund is because of concerns expressed about hospitals closing due to lost Medicaid revenue, but this is not a stabilization fund. This is a transformation fund, meaning you're not getting dollars because you're seeing a reduction in your Medicaid reimbursement. You're seeing dollars on a plan to improve and transform rural health. There's again broad authority given to the administrator that he can recoup or withhold dollars if he determines that the state is not, in fact, adhering to program requirements. So briefly, other healthcare provisions in OBBBA include the temporary payment increase to the Medicare physician fee schedule. That was Monday afternoon, right, Kathy?
Yep.
That CMS released the 2026 Medicare physician fee schedule. We'll be doing webinars later on that particular rule, but it is a one-time 2.5% increase for 2026 versus what the House had proposed, a long-term solution using the Medicare Economic Index, because the one-year fix had $1 billion price tag and the multi-year fix had a $9 billion price tag. Senate decided to go with the one that cost them less in terms of the impact on the deficit. Regarding telehealth, there are now changes to the rules regarding high deductible health plans, not requiring not to be allowed telehealth to be provided without before the deductible is met. Direct primary care, changes in the tax law that allow monthly subscription fees to be used to be paid through HSA funds. And then critical workforce provisions, and we're certainly going to dive into these deeper as time goes on. But there are new caps on student loans specifically impacting the healthcare workforce, and that folks in medical school will now be capped at $200,000 in borrowing. And that, in many cases, is just a fraction of the overall cost of attending medical school. So we have to consider pretty closely what that's going to do to workforce, maybe opportunities as well to support medical students with commitments for service subsequently. And on the other side of this, the new workforce Pell, which allows Pell grants for short-term credentialing programs of 8 to 12 weeks. So maybe new ways to train your own staff. So that's what's in OBBBA that's relevant to providers.
For a physician to go through school well in excess of that $200,000.
Exactly. So certainly things aren't done in Washington. OBBBA was not the last story. There are many things we're watching going forward. Of course, we now begin the 26 there we go. What we're starting the FY26 appropriation process for discretionary funding. We have the president's proposed budget, which cuts HHS budget significantly, cuts CMS budget by 16%. Most concerning in there is that they plan to reduce payments to the Medicare administrative contractors by 30%, though not changing their scope of work, and in fact, in some ways, increasing them. Kathy, you get to talk about that S word.
Yeah, sequestration. I've actually learned to pronounce it, but this is a great concern of mine because of a CBO report that came out, I guess was it in May, as it related to the House bill, and it called for, basically said, as written, what we're going to see is, or need to see, would be an increase in sequestration from the current 2% up to 4%. 4% is the max on sequestration that we could see. So if your hospital is getting $1, you're currently getting 98 cents. You would be getting 96 cents. We have not seen anything beyond that since the final bill was passed. So we don't know if sequestration is hanging out there. If you actually Google it, and if you look for various articles, I believe there was one in Modern Healthcare recently, they say it's coming. So I don't know, but it's something you need to be keeping an eye on. Now, Martie will be clear in sharing with you that there is a way to avoid it. If it passes through Congress, that they will not impose the expanded sequestration, but that would take a 60-vote majority in order to bypass any required sequestration. So one more issue, and if it were to go into place, it would be at the beginning of the federal fiscal year 2026, which is October 1.
Exactly. Well, no, it's delayed till the end of the congressional session. So they calculated at the end of the congressional session, right. So it would go into effect at the beginning of the calendar year. Sequestration is an animal all of its own. Yeah. But it's something we need to keep our eye on and see what's going to happen. We also need to keep our eye on a number of expiring extensions We had the legislation back in March that extended these particular things through the end of this fiscal year, September 30th. Hopefully, through the process of appropriations, we will address the Medicare dependent hospital program, the low volume hospital program, but very importantly, the Medicare telehealth coverage expansion, where we are permitted to provide telehealth services to Medicare beneficiaries in their homes. As it stands right now, that all goes away September 30, and we'll see if Congress steps in to address that. Otherwise, we're going to see a permanent fix for the Medicare physician fee schedule. Are we going to see regulations of Medicare Advantage plans? There's been much interest expressed in that. Will there be expansions of site-neutral payments or price transparency requirements? I won't. I'll bury the lead,
Don't
Kathy,
steal my
as you talk
thunder.
about what's in the OBBBA bill.
Don't steal my thunder.
Exactly. And then, yeah, I will not steal your thunder. But then the other piece is there has been a lot of talk about a second reconciliation bill that particularly will be focused on more Medicaid cuts as well as Medicare cuts, most likely site-neutral payments. And what's very concerning was the amendment that had been proposed by Rick Scott during the debate in the Senate, which was to eliminate the 90% FMAP on the expansion population. There is a lot of interest among some senators to accomplish that. We'll see what happens. So we're not done yet. And while we wait to see what the Senate and the House are going to do next, Kathy, let's talk about ops.
I don't think they want to hear it, but we're going to go ahead and do it anyway. For the outpatient rule, comments, by the way, are due on September 13th. But everything I've seen so far related to the outpatient rule basically says we're going to get an increase in excess of 2%, 2.4, 2.5% increase in our payment rates. You know, Kathy kind of keeps an eye on these things, so let's kind of talk through this. What they have said in the proposed rule is that they are proposing a 2.4% increase in the conversion factor. It would be based upon the inpatient market basket of 3.2%, less a 0.8% productivity adjustment. And then for those hospitals that do not meet the hospital outpatient quality reporting requirements, they would see a reduction in that rate. So bear in mind that they have said 2.4. They've also identified that the outlier threshold would be reduced from 71.75 to 64.50. This would make it easier for a service on the outpatient side to qualify as outpatient. CMS has included in the proposed rule a very detailed table walking through their calculation of that 2.4% increase in our rates, starting with the current conversion factor of $89.17, going through the calculation to do various adjustments on it. You can see that we keep going. We do the calculation to where we actually get to a payment rate of $91.75. That is in an increase over the $89.17 where we are now. That is that 2.4% increase. But those who giveth also taketh away. So let's kind of look at some of the other provisions that they are doing. First of all, if you remember, we've had for a couple of years what was called the 340B remedy. This was when CMS had, or as a result of, the remedy was a result of CMS stepping in and making the decision to reduce payment for 340B drugs to average sales price minus 22.5%. It was found by the courts that they had acted inappropriately because they did not have a survey to support that 22.5% reduction. And therefore, they came up with a way to, I guess I would say, make folks whole. And to make the Medicare program whole. When they had reduced payments by 22.5% for the 340B drugs, what they also did was increase the base rate for all providers. So some saw a cut in their drug rates, but everyone saw an increase in their base payment amount. CMS in their remedy said that we are going to give a lump sum payment to those who were hurt, but we are going to take back from everyone the payment that we made, the offsetting payment to the base rate. the remedy that they published last year said that they would reduce the conversion factor 0.5% for 16 years. This year, they are saying, nah, let's do 2% a year and get it over with nice and quickly, and let's do it in 6 years. For those hospitals that were not enrolled who were not enrolled in Medicare until after January of 2018, this won't apply to you. You're going to get a full payment update. But what happens is if they take that 2% off the base rate, that $91 base rate is now going to be $89.96. So what is that? It's not 2.4% increase. It is an 0.877% increase over your current conversion factor. So recognize all the media that you're seeing saying that you're getting a 2.4, 2.5% increase is not correct. What we're looking at is an increase of less than 1%. Very
well, except for the shiny new hospitals.
Except for the new hospitals, because you didn't have that adjustment because you didn't exist while these dollars are being taken away or being added to your rates. So recognize, very concerning where this is going to take us, and definitely not what we're reading in the media. Not yet. You need to start telling your story. I didn't know whether to say what's old is new again or deja vu all over again, but it's back. Let's look at the inpatient only list. I think you remember a few years ago that CMS eliminated the inpatient only list, and then they realized, oh, this isn't, or they actually began to phase out the inpatient only list, and they realized this isn't a good idea, so they stopped it and they put everything back on the inpatient only list. Well, it's back. They are now proposing to phase out the inpatient only list over 3 years, beginning in 2026, which would be January. They are proposing to remove 285 services from the IPO list. Most of these are musculoskeletal, but some of them also were recommendations from the 2020 hospital outpatient panel recommendations. So 270 something, I guess, were based upon being considered musculoskeletal. The others are those that were recommended by the HOP panel. They are saying that moving forward, that those services that move off of the inpatient only list will be not subject to the Two-Midnight Policy Review until overall data shows that majority of these services are provided in an outpatient setting. So that is a little bit of relief for providers, but we've got one problem here. If I take it off of the inpatient only list, it's not that it's automatically only going to be provided in a hospital outpatient department, because CMS is also proposing to move 271 of those 285 services to the covered procedures list for ambulatory surgical centers. So 276 procedures were already going to go to the covered procedures list. Now they are suggesting that an additional 271, based upon the removal from the at the phase out of the IPO. So very concerning in terms of how this will impact hospitals, both because these services have been provided on an inpatient basis, paid under a DRG. Now we're going to be looking at these services being paid, hopefully under OPPS, but concerning that they might move to the ambulatory surgical setting. So you need to look at your volume for those services. We've talked in the past about executive order from the president back in April called Lowering Drug Prices by Once Again Putting Americans First. Included in that executive order was a requirement that within 180 days, the secretary was to publish in the Federal Register a plan to conduct a survey to determine the hospital acquisition costs for covered outpatient drugs. So this is the Federal Register that does this. It would be a survey they expect submission to begin sometime early in calendar year 2026, where they are going to be surveying all hospitals, not just 340B hospitals, but all hospitals related to their acquisition costs for separately payable drugs. This, if you think about the fact that the 340B payment rate of average sales price minus 22.5 was struck down because they had not done a survey. This is going to give them the information that they need, and they will have the ability to compare it to non-340B hospitals as well, because all hospitals will be required to report on this survey. Can I make it any worse? Yes, I'm not done yet. This is a little interesting idea, but they have always basically used charge master rates to set the relative weights of the DRGs, the MS-DRGs. What they are now proposing to do, and this would be effective for cost reporting periods ending on or after January 1 of 2026, you would be required to report your payer-specific Medicare Advantage payment rates by DRG on the cost report. And this would be your median payer-specific. They use the same word charges, negotiated charges, that should match what you have posted in your machine readable file. But you'd be reporting this on your cost report, and then the goal is by fiscal year 2029 to use this pricing information by DRG to calculate the relative weights. Again, under the inpatient prospective payment system, each DRG carries a weight that is multiplied by your conversion factor to set your payment amount. So they are saying, rather than using charge master specific rate information, they will use Medicare Advantage negotiated rates. So very concerning in terms of what that's going to show as well, in addition to more work, more reporting, addition to the cost report. And let's keep going. Price transparency. There are some new requirements that will go into effect if this rule is finalized as of January 2026. They have indicated that the burden per hospital is a one-time burden of only $478.08. So let's go through what they're suggesting that you do. This goes back to that
Suggesting?
Pardon?
Suggesting, Kathy?
Yeah.
Suggesting that we do? Okay.
All right. Well, it's a proposed rule.
At least it gave us a good laugh yesterday. Yeah, it gave us a good laugh yesterday after we saw that.
I love the $478.08. I really hope that some of you, as you submit your comments, talk to your IT folks and get an estimate of what the burden really is and submit that as a part of your comments. But what they are saying is that they're removing your current requirement to encode an estimated allowed amount. We just had the change that said you can't use 9 nines. You've got to actually have a dollar amount there. And so now they are removing the requirement for the estimated allowed amount and saying that for any negotiated rate that is based upon a percentage or an algorithm, they want you to use historical records, and they are being very clear saying this is your remit, and they want you to calculate the 10th percentile, the median, and the 90th percentile of the allowed amounts that you have gotten paid for that particular service by that particular payer over the last 12 months. And they are essentially saying that your look back period that you have to use is no longer than 12 months prior to posting the machine readable file. And you're going to use those 10th, median, and 90th percentiles to calculate your encoded amounts, i.e. not one estimated amount, but 3. And then you're going to be required to encode on your machine readable file the name of your CEO or other official designated to oversee the reporting of true, accurate, and complete data. You're also going to have to encode your national provider identifier. And they have actually said that if they find you to be in violation of the requirements and there is an enforcement action taken against your hospital, they would allow you to reduce your civil monetary penalty by 35% if you waive your right to an ALJ hearing. I haven't heard that one before, Marty. I don't know if you have. You're the attorney in the group, but yeah. Finally, from a transparency perspective, they have a new attestation statement. The old one just saying basically what the beginning of this is, but the new file, the new attestation statement, not only is your file true, accurate, and complete, but you have included all payer-specific negotiated charges in dollars that can be expressed as a dollar amount, payer-specific charges that cannot be expressed as a dollar amount in the machine readable file or not knowable in advance. You attest that the charge is based on a contractual algorithm, percentage, or formula. You have provided all necessary information available to the hospital for the public to be able to derive the dollar amount, including but not limited to the specific fee schedule or components referenced in such percentage algorithm or formula. So this is your new attestation that has to be encoded in the actual file. And they actually did say, should we, they're asking for your input, should we require the hospital to also have the attestation statement posted on their website with an actual signed by that official, the CEO or other individual. We don't stop there. Let's do drugs. And I guess I mean that in more ways than one.
You have some really good stuff. Yeah.
Site neutral again. Currently, you know that.
We warned you.
Okay. And this is essentially going back again to that same April 15th executive order when the president said, come up with a way to make sure that services are not moving from the physician side to the hospital outpatient department side, address this. So they are doing this in the proposed rule. Services currently that are provided in an off-campus department that does not meet criteria for being accepted are reimbursed at 40% of the hospital outpatient department rate. That is used as an equivalent to the physician fee schedule rate. So what they're proposing now is for 61 codes that relate to drug administration. If it is provided in an exempt, i.e. grandfathered, off-campus hospital outpatient department, your payment is going to be reduced to 40% of the HOPD rate. Just like those non-exempt, non-grandfathered facilities, this is now going to come to all off-campus provider-based departments, whether you're exempt or not. Drug administration that is done within the hospital itself would continue to be reimbursed at the full OPPS rates. They expect that this will be about a $280 million savings to the Medicare program, and also savings from a beneficiary co-insurance perspective. It's not being done budget neutrally. However, they are exempting rural sole community hospitals in this particular provision. Heaven forbid that they do this without asking for your input, because they are also asking for any additional services that perhaps should be subject to site neutral payment reforms. So wanted you to know.
And Kathy, the questions in that RFI are incredibly aggressive. I mean, it's basically, I mean, they go as far as to say, should there be absolutely no differential, regardless if it's on campus or off campus. And so it's begging for comment, or we're going to get what it's going to be the extreme, is how far they're really laying the ground for. So this is just the first round.
Martie, we have quality reporting on outpatient, and we have home health. What should we do? I turn it to you.
We should skip them and say the key elements are on the slide. So you'll see the changes to the outpatient quality reporting program. Again, we're just mainly changing certain measures to be reported. And we also have the sorry there, Kathy. There we go. The star rating changes is just that we're now going to finally put a cap on the stars that you can achieve if you fall in the lowest quartile of the safety of care measure group, saying that no hospital that can't score well on the safety of measures should be deemed a 5-star hospital. Kathy, back to you.
Just a few things of note, addressing permanent virtual supervision for pulmonary rehab, coronary rehab, intensive coronary rehab, and rehab and diagnostic services. There is an RFI on software as a service, and this is essentially using AI and other such products to support clinical decision making. Should there be a separate payment for this? They are proposing separate payment for skin substitute products as incident to supplies in both the non-facility and the facility perspective settings, and some applications. They address 7 applications for pass-through payments. As we talked about with the inpatient rule, there is an RFI on deregulation. What kinds of regulations cause burden? Please comment on this. But let me touch on home health very quickly, because comments are due on the 29th of August. If you have home health agency, let's just get it over with on this one slide and say that they are looking at a 6.4% reduction in current payments, which would be a $1.4 billion decrease in payments for home health agencies from 2025 to 2026. A number of adjusters that they have taken into effect, but the main provision of this $815 million is tied to a temporary adjustment where they are working to recoup past overpayments. This is based upon a behavioral assumption saying that when we changed from the 30-day payment methodology to the implementation of the PDGM program, there were changes that were made in behavior, and we are paying you too much, and this is their attempt to begin that reduction. Overall, that they're looking at about $5.3 billion that they believe has been overpaid on to the home health agencies, and this is their attempt to begin, taking that back. Martie, do you want to do wiser?
In fact, there are also, you all, of course, know that you get the slides from the presentation by email later today.
And we're always ready.
The details on the.
Let me go to this one.
Absolutely.
Before we do wiser. Oh gosh.
Okay.
We already said things are coming out of the woodwork. Here we go again. I think you're probably aware that there is a moratorium or a temporary gap in the DME competitive bidding program. It basically just kind of shut down. Well, they are raising it, or the specter of it again. They are addressing improvements to the competitive bidding program. They haven't done anything as it relates to the announcement of product categories that would be subject to this. However, they are saying that certain supplies such as ostomy, tracheostomy, and urological supplies are medical equipment and would be included under a competitive bidding model. They haven't said anything about a time frame for the next bidding, but they are starting to raise issues as it relates to the competitive bidding program, even looking at payment for class 2 continuous glucose monitors and insulin infusion pumps, and classifying where these fall and whether or not they would be subject to competitive bidding. Marty?
So briefly, again, slides will have more detail on the home health rule as well as the ESRD rule. Just briefly touching on Wiser, which is a new CMS Innovation Center model. The participants in this model are actually companies that would contract with CMS to perform prior authorization reviews, and they would be compensated from the savings to CMS of preventing improper payments. Detailed in the RFI, the RFA, request for application for these companies, are the specific procedures for which these new prior authorization requirements will now apply. These are in addition to existing prior authorization requirements within traditional Medicare. So these are new obligations. This initial program is limited to 5 states that you see there on the screen. And this is intended to start in January of 2026. So a very different type of alternative payment model, but clearly intended to be the aggressive use of artificial intelligence in performing prior authorization reviews within the traditional Medicare program. So definitely keeping our eye on this one. Finally, just to close out, we are also reading the Medicare Physician Fee Schedule final rule. Proposed rule, my apologies, which came out Monday afternoon. We will cover this in 2 webinars on July 30th and August 13th. We apologize for moving relatively quickly today. We were very surprised at everything that was in the OPPS rule.
And the OPPS rule
there.
literally came out yesterday afternoon at 4:20.
And I'm on Pacific time, so it was only 1:15 for me. But anyway, I have a little more time than Kathy did to play with it. But again, really thank you for joining us today. If you have questions, please do include them in the survey. We'll do our very best to get back with you. And Jennifer, back to you to take us home.
All right. Thanks to our presenters, Martie and Kathy. Please remember to stay on the line once the webinar disconnects to complete a short survey. Later today, you'll receive an email with their contact information and a recording of the webinar. Also, the slides and recordings for every episode of PYA's Healthcare Regulatory Roundup series are available on the Thought Leadership section of PYA's website, pyapc.com. While at our website, you may register for other PYA webinars and learn more about the full range of services offered by PYA. Please remember to stay on the line once the webinar disconnects to complete the short survey and post any additional questions you may have. On behalf of PYA, thank you for joining us. Have a great rest of your day.